So friends, right now, let's move on to understanding another aspect in what we call as the essentials of a contract, which can be vitiated through, aspects of grounds that may affect free consent. So we know that free consent is an essential ingredient, and the parties have to agree on the same thing in the same sense. That is the principle of consensus at idem, right? So once you agree to the same thing in the same sense, then there is a contract, right? So the meeting of the mind theory, right? The two parties should agree to the same thing in the same sense is a very important core principle in contracts. And hence, anything that is going to affect, like coercion, undue influence, misrepresentation, are factors that may affect the making of a contract. The aspect of fraud is a very interesting aspect because I think this is something that is very commonly used term whenever you feel cheated, whenever you feel that there is not a fair deal. Any common man will say that a fraud has been committed. Now, fraud can happen in all kinds of contracts, and this is quite a common feature of what we call as the exploitative market. So the fraud can be committed either by sellers or by the buyer, as the case may be, whoever thinks that he can get away with so-called cheating attempts to commit a fraud. Now, interestingly, friends, fraud broadly is also covered under criminal law. You know that the Indian Penal Code also deals with fraud, cheating, and such other factors where you can actually be punished with an imprisonment or a fine. Fraud also gets covered in personal laws, especially marriage laws. You notice that when a person in a marriage actually misrepresents his age or his status or his caste, so on and so forth, then we say that fraud can be a ground for annulment of the marriage or for divorce as well. Interestingly, that is where fraud is a branch of misrepresentation. So misrepresentation can be said to be of three categories. One is innocent, the other is negligent, and third is fraudulent. Now, the status of mind in these three are critical and important. Now, fraud is something that is done deliberately. Fraud is something that is done mischievously. Fraud is done with an intention to deceive. So the person who actually makes the representation, right, in fraud knows that he's making a misrepresentation. He knows that it's untrue, but he deliberately decides or chooses to do the same with an intention of getting the other man's consent in the contract, thereby then trying to state that, look, here is an unfair advantage that I'm going to get. So he knows the situation pretty well. He knows the market condition. He's probably done it in the past, and that's why he continues to deceive people while making this. So intentional misrepresentation, deliberate misrepresentation, reckless misrepresentation that affects the safety of the other party, that affects the rights of the other party, can constitute as fraud. So fraud is a very serious categorization of an injury. It's a serious categorization of affecting the rights of the other contracting party. And, obviously, if a fraud is committed upon you, especially in a contract by which your consent has been sought, then in those circumstances, you will have every right to go to the court and set aside the contractual obligation, plus probably claim damages in case you have suffered any kind of an injury to yourself or to your property through the fraudulent misrepresentation. So I think the courts do treat fraud in a very serious manner, and that's probably the reason why this part of the contract becomes a critical factor. Not to forget that there are a lot of frauds that are committed with government contracts. These are frauds that we say are, false documents being submitted when the tendering process is being done. So a lot of companies or a lot of contractors and bidders want to qualify themselves to government contracts. They know that they do not fulfill the entire criteria as laid down in the tender document, and hence they may actually submit false documents. They may actually commit errors in submitting these documents. And hence, in many of these cases, fraud can actually be established if it is done intentionally. If it's not done intentionally, if there is a general error in the understanding of the documents to be submitted in a tender, then it can be called as just negligent misrepresentation. So I think one needs to understand that though the line between negligent and fraudulent misrepresentation is a very gray area, it nevertheless clearly states that if someone is not cautious enough in submitting the tender document, he has not checked his facts and figures, then it could be negligent misrepresentation. But if I falsify and create a new document where there is none, then it's a clear case of fraud in that case. So I think the idea of cheating, the idea of trying to gain from market conditions in an intentional, deliberate manner creates fraud as a special category as well. So the case at hand is a very interesting case, but a very old one, probably giving us some idea about how misrepresentation and fraud evolved over a period of time. Is a case of Ward versus Hobbs. It's a very interesting case about animals being kept on sale. Generally, if you go to some village areas, there will be a fair where certain cattle may be displayed, and you can actually purchase that cattle or those kinds of animals. Now, the subject matter of sale in this case were pig. And obviously, there were a couple of pigs. They were cordoned off in a particular area. Quite early days and early times when we had an agricultural or animal husbandry kind of an economy or a market. And there was a seller, right? He was ready to sell his pigs. So what he did was he had an interesting representation. And his representation said, pigs with all faults. Yes, please be correct. Pigs with all faults. Now comes a buyer. He's interested in buying pigs. He looks at it. He says, pigs with all faults. Yeah, of course, animals have certain faults like any other. So he said, okay, must be some faults may be there. That's fine. It's okay. I am a pig farmer. So that's not a problem. I can probably rectify the faults, which this seller cannot do so. So what did the buyer do? Despite having been said that the pigs are with fault, he decides to buy those pigs. He buys the pigs. Then he takes them to his own pig farm. Now, unfortunately, the pigs had a typhoid fever, right? The ones that were sold, the new ones that were bought, had a typhoid fever. And you know that the typhoid fever can be communicable, right? It's a communicable kind of a disease or an illness at that point of time. So the new pigs, when they entered the farm, they actually spread this typhoid fever to the other pigs. Right, and the whole lot of pigs, unfortunately, were affected, and the buyer got aggrieved. Now, being aggrieved, he sued the seller, and he said, "Look, a fraud has been committed upon me. I should get the right to set aside this contract. Plus, additionally, please note, I have suffered damages. What was the damage? That look, the other pigs who were healthy in my farm were affected or infected by this particular kind of an incident. So I need damages as well." Now, the seller, on his part, definitely defended this. And he said, look, I had already said that the pigs are with fault. I have not made any kind of misrepresentation. See, misrepresentation, friends, or even fraud, is kind of a positive statement of things. It's a positive assertion, right? In this case, what did I say? I said they have faults, which is very clear. So it's a positive assertion, but did you even verify what those faults were? Right? I did not hide. I said they had faults. So even if you say that fraud is about hiding things, I did not do the same. So the seller put the obligation into the buyer's court, and he said, look, there is a principle called caveat emptor. Let the buyer beware. Now, in this case, did the buyer actually ask me what those faults were? I would have told him. The buyer should have checked. The buyer is a pig farmer. He is someone who is in this business. He must have known that this is a problem. This can be a challenge. He should have checked and he should have taken. So can the buyer always put the obligation on the seller and say the seller is at fault and the seller alone has committed fraud? As I told you in the past, friends, one thing that we have to understand is, yes, it can be a consumer market. Yes, pro-consumer legislations are there in place, including legislations as early as the Sale of Goods Act of 1930. We are going to discuss that a little while later. We have consumer legislations like the Competition Act of 2002 and the recent Competition Act of, the Consumer Protection Act of 2019. The earlier one was the Consumer Protection Act of 1986. So there are so many pro-consumer legislations which protect the consumer who is an innocent consumer. right? So he feels exploited by the market conditions, and hence, yes, there should be a law which would say caveat vendetta. Let the consumer be the king, the seller beware. But the point here is, can we always say that the seller has to be there? I don't think so. For the simple reason is, I think the buyers also have an obligation. Now, did the buyer, by any chance, could he have found out what these faults were? If he was interested, if he was aware, if he was cautious about his own obligations in a contract, I think the buyer could have found out. So it's not that representation or misrepresentation is only the issue. If the buyer could have found this out or discovered the truth, and that is how the law is designed. The law says if the buyer had any element of discovering the truth and he failed to do the same, then of course the buyer has contributed to the fault. And because the buyer has contributed to the fault, the buyer may not get the remedies as he wishes to do from the court of law. Look, in this case, I think the buyer was at fault. He contributed to the fault. He did come to the court with unclean hands. Once there is a display of saying, look, these are the faults, the buyer should have checked those faults. He must have tested it. He must have asked. And without doing the same, I think the buyer cannot always blame the seller in this case. I think the seller had done his obligations sufficiently enough to evade any kind of liability, though cleverly sometimes. We may say, though mischievously sometimes, because he says, with all faults. Why shouldn't he have said what those faults were? But nevertheless, I think the court in this case went with the seller, gave the decision against the buyer, and said, look, caveat emptor applies in this case. The buyer was negligent. So one who seeks equity, and the buyer in this case wanted equity, should do equity. Right? You must come to the court with clean hands. You must not have contributed to the fault. You must not have contributed to the breach. And hence, I think the court said caveat emptor applies. Now, this was time when caveat emptor was prominent because we were not looking at consumer interest, right? So, if you look at it from a consumer perspective, I think this is a different perspective, right? This was a time when I think the buyers and the sellers were presumed to be equal in their bargaining capacity, and that was the time this case actually was decided. And that's why we say in contract, it is very important that when we discuss some of these principles and cases, we have to understand that there are contracts that have to be segregated as one, B2C contracts, that is business to consumer contract, where probably the principles could be dominantly caveat vendetta, let the seller beware. The second is B2B contracts, which we call business to business contracts, where though both the contracting parties are supposed to be in an equal footing, they are having an equal bargaining capacity. And in those circumstances, I think the caveat emptor principle will apply. So the courts in India also have said that there is nothing wrong in principles of caveat emptor in a B2B contract. And similarly, do not forget, then we are talking of another type of contract, which I think is relevant for this course, is called B2G contracts. That is business to government contracts. And in those circumstances, I believe, friends, that in business to government contract, it is important for a lot of us to understand that the government usually is in a higher bargaining position, and hence it is weak to say that the fraud was committed by the contractor. So the government has a higher bargain in that case. Nevertheless, I think the government should be aware, while it is awarding contracts, that it cannot put the entire responsibility on the contractor. The responsibility of the government is equally there, and that is sufficiently significant for the government to take note of these circumstances. For example, could the government have discovered the truth of a false document that was submitted in a tender? And they did not discover the truth. They did not take efforts in discovering the truth. In that case, the government cannot take the risk of saying, oh, a fraud has been committed upon us. Because the government must take its responsibility in finding whether the documents were authentic or not. That kind of verification or scrutiny, as we call it in tendering contracts, must have been done. So, if you have the ability and if you fail to exercise that ability of discovering the truth, a fraud cannot be made out. Yeah, that's very clearly what is there in the contract law. Now, as we go further, friends, there's this very interesting point about whether silence can amount to fraud. Now, the reason why we are asking or discussing this question is very clear, friends, is because we say representation. Representation is something that is positively said. Let's imagine that I do not say anything at all. Now, I remain silent. Will that amount to fraud? Now, the concept, friends, is about concealment, right? You should have said, but you did not say. You had an opportunity to say, but you did not, because you know that if you had said it, it may amount to fraud or misrepresentation. So you choose to remain silent. So can silent amount to fraud? This is a very important question that probably needs to be answered with the help of these two cases, the Shri Krishna versus Kurukshetra University case and Skies versus Rose case. See, the Shri Krishna case is a case of a student. It's not necessarily contractual one, but it is about the general aspect of fraud. See, a student was asked to fill an examination form in which he had to actually disclose whether he had attendance requirement. You know, the UGC says that there must be minimum of 75% attendance if you should qualify to write the exam. It can be 60% if you have some medical certificate, depends upon university to university. So this guy, when he decided to fill the form, he did not fill that column. He left it blank, right? He was supposed to fill it, but he left it blank. Now, is that amounting to silence? Yes, it is, because you choose not to answer. Now, usually you will say that if there are certain columns which are not applicable to you, you say NA, right? You say something, but you don't leave a column unattended, right? This student decided to do that. So he then, got the examination hall ticket. He wrote the examination, and later on, the university comes to know that this guy had an attendance shortage, and he should not have got the opportunity to write the examination. And the university claimed that the student had committed fraud. Now, the court in this case did consider the fact that silence may amount to fraud, yes, either contractual or otherwise. But shouldn't the university have been able to discover its own truth or verified what the student has answered or not? Because finally, who has the attendance record? It's not the student who has it. See, I come to the class, I attend. It's the teacher who marks the attendance, and the university has the records of the same. How will I exactly or precisely know whether I have attendance or not? I may say, yes, I still have, but it's for you to have checked it and then probably allowed me to write the examination. So, did the university have any opportunity to discover the truth of the so called fraud that was alleged to have been committed? If they do have, then I think a case of fraud may not be made out. You must have exercised your own diligence in trying to find whether a fraud has been committed on me. If you choose not to exercise the same, then that is your fault and not the fault of the student. The interesting case that we should look up to is the case of Skies versus Rose. This is an English case. It's a very interesting case of a property being put up on sale. It was a house that was put up on sale. Now, the buyers, they went to see the house. They liked the house. They liked the price. They almost finalized saying, yes, we will go ahead and buy it. And, they asked a final question to the seller. They said, look, is there any other information you think we should know? This is what a question that the buyers posed the seller. Is there any other information you think we should know, or you wish to tell us? The seller looked around and he simply said, no, I think you like the house, you've seen everything. The price has been agreed. I think everything is fine. I have nothing more to disclose. Right? Now, generally, this can be done either orally or it could be done through a sheet of paper where the seller has to actually write certain things and then that can be circulated. Because in the United Kingdom, they have a special legislation on real estate law. Most of the real estate can only be bought through agents, and the agents actually owe responsibility both to the seller and the buyer. They have to try and disclose all facts to both the parties. Right? They have to be fair to both the parties so that any case of cheating is not made up. So the seller in this case does not say anything special. The buyer decides to buy the house, close the deal, pay the cash, and get the keys to the house. Now, what happens was, very interestingly, the facts of the case are quite detailed. Let's not go into that. But in this case, the buyer moves in. He likes the house, he checks in, he settles down, puts all the furniture in place, and then decides to, speak to his neighbors. Right? You have to get friendly with the neighbors, know each other, and so on and so forth. So they start finding out the neighborhood, and at that point of time, when they were trying to become friendly with the neighbors, they come to know of an information. And what was that? The information was that the seller was in a hurry to dispose the house. Why? Why? Because a couple of months back, in that house, a gruesome murder had taken place. And that's the reason he was keen to sell the house. He was no longer interested in that house. Now, the buyers felt that this was a critical information, a very fundamental, important information that should have been told by the seller. And the seller chose not to say the same, and he chose silence over that matter. So the buyer now wants to repudiate the contract. The buyer wants to hold the contract as being violable. So what the buyer does is he goes to the court. Actually, in this case, the buyer decides to sell the house, and what happened in that is the sale price was much lower, because at this point of time, the buyers say, yes, the gruesome murder had taken place, so the house got a lower price. And for that, they sued the original seller, saying that, look, had you told this information, we would never have bought this house. Now that we gave this information out, we got a lesser price, and hence you are totally responsible for the damages that is caused by your silence, which amounts to fraud. So the matter goes to the court of law. It's a very interesting case in the sense that once it reaches the court, let's apply the caveat emptor principle. Should the buyers have checked for this kind of information? Let the buyer beware. So when you're buying the house, are you sensitive for what has happened inside the house, say in the last 6 months or 6 years? Whether a murder has taken place, whether there is domestic violence that has happened, whether a theft has taken place. Will this be a fundamental information that will affect the consent in the contract? I think that's very important for us to answer, because remember, misrepresentation or fraud are not the fringe issues that are discussed in a contract. They have to be core, fundamental. But for this, you would not have agreed to the contract. That has to be established, right? So you must have said, like, but for this information, which has gone untrue, probably I have not have chosen to buy the house. Now, I believe that most buyers, probably, they don't ask for all this information. Should they ask in the first place? That's the question. And suppose a murder has taken place already in the house, does it mean that that house cannot be sold at all? It can be, but should you disclose it? Now, you notice, friends, most sellers are very clever, because we say it is the vendor or the seller. He only tells you good things about the house because he has to convince you to buy the house. Do you find normally sellers telling you the bad things of a house or the disadvantages of a house, or saying whether the house is auspicious, lucky or not? Sellers choose not to say this. Right? They may choose their silence. That's their choice. And it is probably this buyer's duty to find out if he is sensitive enough to murders and other things. Right? Or for example, in India, we say Vastu and so forth things. So if you are actually very superstitious and religious, spiritual, and that is the reason why you are choosing a particular house, then you better find out. That's your responsibility as a buyer. It cannot be entirely on the seller to say that the seller's silence has committed or happened to be a fraud. On the other hand, if you look at the seller's obligation, look here, friends. The buyer had posed a question. What was the question? He said, do you have any other information that I wish or I should know? That's an extra question. And that point of time, the seller could have disclosed this, isn't it? I'm not sure. But I think the buyer says, look, we did ask the seller. That was an extra question. But the seller did not disclose anything. So I think to a larger extent, this case clearly establishes that silence can amount to fraud when, please note, when the law imposes a duty to speak. Yes. That time silence will definitely amount to fraud. Now, what is the duty to speak? Now, friends, please note, in this case, my argument would have been that the seller should or will have to speak and say that a murder was taken place 6 months back, a gruesome murder, if that house is still under investigation, is still under forensic investigation or forensic evidence, or the police is actually visiting the house to actually put across the court case, or the house is utilized for, say, insurance and other purposes, which may affect the peaceful enjoyment of the property of a new buyer. In those circumstances, seller has an obligation and a duty to speak. Anything that affects the peaceful enjoyment of my property, if the seller does not disclose the same, that non-disclosure is an active concealment. What is active? Knowingly you don't disclose, purposefully you do not, actively you hide the information. In those circumstances, silence may amount to a fraud. But where there is no duty to speak, I think let the buyer beware. He has to check the facts and circumstances. It's a similar thing when it comes to automobile, friends. A two-wheeler or four-wheeler that has met with an accident. Do you think sellers who sell two-wheelers and four-wheelers tell you that the car has met with an accident? Do they have a duty to speak? Do they have an obligation to speak? Should they disclose? Can they keep this under active concealment? Look, if a vehicle has met with an accident, every vehicle meets with an accident. Now, should every seller keep saying this? Is that a duty? However, if suppose because of a previous accident, the safety of the car is compromised, would at that point of time the seller have a duty to speak? And this non-disclosure, can it amount to fraud? Active, knowingly, deliberately. If I say this, he won't buy. That is fraud, right? Or imagine that the vehicle has met with an accident and the motor vehicle claim or the motor vehicle insurance claim is still pending. It's not been settled. There is a tribunal, there is a court, there is a claim, there is a third party, someone was injured. All this is still pending, and despite all that is pending, you don't disclose the same and you sell it to the buyer. This will affect his peaceful enjoyment of the property after sale. Every seller has a duty and obligation not only to transfer title, but to see that the buyer has the entire possession of the goods with title and peacefully, so as to enjoy the goods safely as well. Anything that affects the interest and the rights of the buyer adversely, the seller may have committed fraud in that case. And that's why we say, wherever there is a duty to speak, non-speech of the same will definitely amount to fraud. Right? This is precisely how we probably look at even government tendering or government contracts. Every contractor or a tenderer has a duty to speak, because we say this is a fiduciary relationship at times. Right? When we say fiduciary relationship, friends, please note, in fiduciary relationship, whether you have been asked or not, you have to speak. Like in insurance contracts. Say, suppose the insurance contract very clearly says that, look, if you have any previous ailments or surgery that has taken place in the last 4 years, you will not be entitled to a medical insurance. You choose not to disclose, knowingly, deliberately. Fiduciary relationship has been broken. There is a breach of trust. Right? You have to speak in contracts of utmost good faith, friends. You will notice that whether you've been asked or not, you have to speak, you have to disclose. That is your duty. Right? So it's not misrepresentation. You choose not to speak, that is fraud. Right? You may say, oh, what did I speak? I did not speak at all. Right? That can also be fraud. So allegations of fraud can also amount to contracts which are of utmost good faith, which are of fiduciary relationship, where you have a duty to speak, you are bound to speak, and your silence can definitely amount to misrepresentation or fraud. Depends upon the intention of the other party as well. So this is something that you will definitely see in many contracts. Fraud is a major ground for holding contracts being voidable. The consent was sought but on that ground. And in modern day contracts, you will notice that the courts intervene, go by the evidence, go by caveat emptor principle as well, to decide whether an issue or allegation of fraud can be made out or not.